Our next speaker will be talking about empowering consumers, a subject near and dear to my heart. He's a professor of law at Georgetown University Law Center, where he teaches federal court, civil procedure, administrative law, and seminars in First Amendment litigation.
So I spent a mere 25 years working for Ralph. I will never forget my interview with Ralph. The first question was, did you read the paper today? And yes, I had. And he said, okay, what made you really mad? And so let me talk about what makes me really mad about the state of consumer protection in the United States. So Ralph talked about the blasphemy of what's going on with food protection. Well, the blasphemy about consumer protection in the United States these days is that very strong notions of freedom of contract are essentially corroding what we think of consumer protection. And this is a pincer movement that comes from two angles. One comes from essentially the disintegration of tort law contract law as we know it. These days, consumers ordinarily have no bargaining power with respect to the contracts they sign. These are often, the I accept little box at the end of a form contract that you may or may not read. In many instances, consumers are not even presented with the contract prior to entering into them. The contract is available, if at all, after the fact. And in those contracts, there are generally provisions that would have been unthinkable 30 years ago. So one common provision gives the seller the unilateral right to modify the contract. So if the seller decides, well, I think I can sort of eke more out of this relationship with the consumer, they're free to modify the contract and send you a little note down the road. There are all sorts of sort of bombs put in these contracts that often go off to the detriment of consumers. So one, and I'm going to come back to this, one sort of ubiquitous contract provision these days is a mandatory arbitration provision, which requires consumers to go to a privatized system of justice that's essentially invisible rather than exercising their rights in court. But I'm going to come back to that. But there are other waivers that are generally attached to modern contracts. For example, forfeiture of remedies that one might be entitled to under statute. So for example, in many cases that involve contracts, a disappointed consumer would have the right to have his or her case heard before a jury. Well, contract provisions these days often include waiver of the rights of jury trials. Contracts also include the forfeiture of remedies that would otherwise be available to the consumer under state law. Many of the contracts you've entered into require you forfeit your right to punitive damages. You forfeit your right to statutory damages. Often statutes contain what are called liquidated damage provisions, provisions in which certain amount of damages are assumed. Those provisions are also those rights, statutory rights, are often waived in contracts. So you're asking, wait a minute, these are statutory rights. These are rights Congress thought were important enough to enshrine to statute to guarantee the consumer has this remedy in the event of breach. How could those rights be waived? Well, the Supreme Court has held in many cases that arbitration substitutes the procedures and indeed oftentimes some of the substance that would otherwise be available if resort to court were available to the consumer. So for example, the Supreme Court has upheld arbitration agreements even where it is clear that a statutory right cannot be vindicated in arbitration. So even where it is clear, this is a case called Italian Colors, where rights that Congress thought were important enough to enshrine in statute could not be vindicated through an arbitration agreement. Tough noogies. The right is now unenforceable. And class action provisions also often include sacrifice of procedural rights that would otherwise be available. If you sue in court, you have certain rights of discovery. You can get access to the other side's documents. You may be able to take oral statements, depositions of witnesses who have information that's pertinent to the case. Class action rights are often afforded by statute that are abrogated by contract. So the kinds of form contracts that we see today not only deal with the underlying transaction, but include essentially a long list of rights that consumers forfeit by entering into a contract. And the courts have shown no interest in pushing back. Making matters worse, the court's arbitration jurisprudence has been essentially go away to consumers. There are a number of cases involving forum contracts, a case involving AT&T, where the court split 5-4 on the enforceability of these consumer contracts that could only be vindicated by groups of plaintiffs suing together because the dollar amounts were reasonably low. And so one form of assault on consumer protection has been the courts enforcing contracts literally, even to the extent that they sacrifice statutory rights, and the Supreme Court's aggressive affirmance of private dispute, private ordering over transparent judicial proceedings where the public at least has some insight into what's going on. The second form of assault, and this gets back to Mike's point earlier about shrinking government. So 20 years ago, Grover Norquist famously said his goal was to shrink government to the size where it could be drowned in a bathtub. And in a large measure, he has succeeded. So if you look at the staffing of the important federal consumer protection agencies, they've been hollowed out. I was the director of the FTC's Bureau of Consumer Protection for 4 years. The FTC today is about 2/3 the size it was 20 years ago. The population of the United States has grown by 1/3 and the economy has doubled, yet the number of regulatory cops on the beat has shrunk. And if you go up and down the list of the regulatory agencies we all depend on for our health and safety, they are quantitatively smaller. I mean, my colleague, my former boss, Joan Claybrook, was head of the National Highway Traffic Safety Administration, responsible for overseeing auto safety, truck safety, tires, everything that moves. They have about 600 people to regulate the entire global automobile industry. Really? I mean, that is sufficient? The Commodities Future Trading Commission, a small agency, but has regulatory authority over most of the commodities trade in the United States, is about the same size. The FTC, which has both consumer protection and antitrust authority, has about 1,100 people, in contrast to the 1,600 that it had in the 80s and 90s. Even the CFPB, the new sort of, the first line of defense in terms of financial products and services, at the most will end up having about 1,400 people. So when people rail against the size of government, you need to understand that with respect to the agencies we depend on to protect us in the marketplace, those agencies are very thinly staffed, they're overworked, and to make matters worse, the states, which used to be an equal partner in consumer protection matters, have also been hollowed out. When I was at the Federal Trade Commission, I worked very closely with colleagues in state attorneys general's offices. They too have been cut massively because of budgeting and other state restrictions. So to the extent that we depend on government to be our first line of defense against egregious misuse of marketplace power, the government does what it can, but it is a very thin line that is spread thin. And I want to echo another point Mike made, which is there's a lot of talk about agency officials being feckless, not being tough enough. Well, they're between a rock and a hard place. The tougher they are, the more they face funding cutbacks. When I was at the FTC, we were very aggressive, and I was called up onto the Hill with some regularity to basically say, you know, your funding is in jeopardy, and you've got to be careful. And so it's a very difficult position for federal regulators. Let me talk about one other market failure, which is the courts, too, have been equal partners in some extent in the ratcheting back of consumer protection. So take one field. So identity theft is now rampant in the United States. Last year, the Justice Department estimates that 17 million Americans were victimized by identity theft. I measure this because the Federal Trade Commission has essentially a self-help part of its website where people who have been victimized can go and get access to standardized police reports and other forms that they would need in order to try to reclaim their own identity. Last year, 500,000 Americans used that site in order to file claims about identity theft. So the identity theft is the predictable debris of an internet economy where data security is not taken seriously. And so this is an area where Congress has refused to act. The Federal Trade Commission and other agencies have asked for authority to force the people who store your data to take adequate steps to safeguard it. Ironically, of course, they safeguard their own intellectual property data very well. Your data, your payment card information, your social security number, the prescriptions you take, whatever other personal data these companies have is not very well protected. And part of the reason is because there's no economic deterrence for companies to have lax security. The courts have repeatedly turned away people claiming injury from identity theft. And the Supreme Court's recent decision in a case called Spokio versus Robbins still leaves unsettled the question about whether you have a right to sue when your personal data has been compromised due to a data breach. So, all right, so that's the assault. And the assault is real, and the erosion of our rights has been steady and predictable for the last, I'd say, decade or 20 years. So what can we do about this? Well, there have been some bright signs on the horizon. The passage of Dodd-Frank and the creation of the Consumer Financial Protection Bureau is an enormous step forward. Now, the agency has been in existence for only 4.5 years, but has already done some important things. It's taken some enforcement actions. It's done policy work to protect those people who are not entitled or not eligible for anything other than subprime loans, to protect them in the market. It has proposed some curtailment of the right to mandatory arbitration, but that's just the first step. That agency is under assault constantly in Congress. I talked to my friend Rich Cordray. He has stopped counting the number of times he's been hauled up to the Hill to testify. It was, I think, 50 at last count. He's only been there for a few years. We need more legislation, and in order to do that, we need to organize, we need to personalize these stories, and we need to look at the lever of powers that are available to us and tries to exercise power. So let me talk about a few things. One is, if you look at mandatory arbitration, Congress understands how powerful a force that is. There are exemptions to it. When Dodd-Frank was passed, the most fierce lobbying was not done by the banks. It was done by the auto dealers. Why? Because they wanted a provision in the bill that made it illegal for the auto manufacturers to require the auto dealers to arbitrate disputes. It's one of the few odd carve-outs in Dodd-Frank. Well, the auto dealers had a point, and we need to force Congress to take a hard look at arbitration, at mandatory arbitration. And the only way we're going to do that is if we come up with a number of stories that drive home just how unfair, undemocratic, and essentially how perverse that process is. The other thing that we need to do is we need to win the battle in the courts, and this is where you're going to hear from Paul Bland and people from Public Citizen Litigation Group early on. We've been fighting these battles in the court, but the court is now up for grabs. Justice Scalia's seat remains vacant. Justice Ginsburg is 83. Justice Kennedy is 80. Justice Breyer is 78. The next president will remake the Supreme Court in all likelihood. Most of the decisions that I've been fretting about have been 5-4 decisions. One vote can make an important difference, and one vote on November 8th can make a huge difference. Thank you very much.
Our next speaker will be speaking about stopping corporate power and money in politics. He is the president of Public Citizen, a group that you have heard about and you will hear again today. He's been leading Public Citizen since 2009, where he is now spearheading the effort to loosen the chokehold that corporations and the wealthy have over our democracy. Following the Supreme Court's decision in Citizens United, he established the Democracy is for People program, which is a project of Public Citizen, and it's specifically intended to fight for a constitutional amendment to overturn the ruling and curb money in politics. Robert Weissman.
The story of conventional wisdom, which is that America is a country deeply divided. We're red and blue states. I heard some detailed reporting on this on NPR this morning with some actually interesting reporting and some shocking views. We're plainly a country divided profoundly by race and equally as profoundly and less often recognized by class. And I'd say that political story, that's the dominant narrative about to try to explain what's going on in the country, that we're a divided nation. And it has some truth. That story has some truth. That's why it works. But it overshadows another story that is at least as important, I think probably more important, which is that we're actually an amazingly united country when it comes to the policy agenda that Americans favor. Astoundingly united. So I'm about to read you a set of statistics, but by way of background, compare them to the fact that 4 out of 5 people agree that the Earth revolves around the sun. So that's a marker. And it's not that's, as an aside, Claire, that's not nothing to do with American science teaching. It's cross-culturally true. That's about the number when you look across countries. However, 83% of Americans think that the top 1% have too much power and have used it for economic advantage. 3/4 of Americans favor a steep rise in the minimum wage. By about 2 to 1, people oppose corporate trade deals like the Trans-Pacific Partnership. The vast majority of Americans favor breaking up the big banks. About 9 in 10 say we need stronger financial regulation. 4 out of 5 voters favor expanding Social Security, not protecting it, not defending it, not stopping cutbacks, but expanding Social Security. By 3 to 1 margins, Americans want to close corporate tax loopholes. The president's controversial Clean Power Plan is favored by a 2 to 1, a small 2 to 1 margin. 3 out of 4 Americans favor stricter air pollution standards. The Clean Water Act has 80% support. If you give people the completely ridiculous and misleading choice between environmental protection and cost to the economy, 59% say they want stronger environmental protections. More than 9 in 10 Americans want origin of labeling, country of origin labeling for meat. 83% of Americans favor giving Medicare the right to negotiate drug prices. More Republicans rate drug prices as a higher, Republicans rate high drug prices as a higher level concern than Obamacare. They're more concerned about drug prices, Republicans, not the country, than Obamacare. Almost 9 in 10 Americans say that we should have tougher enforcement of law and regulations that apply to corporations. So there is an amazing consensus in the country behind a progressive populist agenda. There's also, as David, Michael, and others were saying, amazing lack of progress on that agenda. So there's this huge disconnect between what Americans want by overwhelming numbers and what we get. What do we get out of Congress? What do we get out of the executive? What do we get in the states, out of city councils? And you can't explain that adequately, in my view, with anything other than looking at the power of corporations and especially the power of the corporate class in our elections. So corporate political power is not only expressed through money in politics, but that's the cutting edge. And the problem long precedes, of course, the Citizens United decision that Oliver was talking about in 2010, but it got a lot worse with that decision. That decision held that corporations have the right to spend whatever they want to influence election outcomes. Most of you probably are not in the business of reading Supreme Court decisions, but if you want to pick one, although it's a long one, it's worth reading Citizens United because it is astounding, and even though it's got some law stuff in there, you'll understand immediately why it's astounding. It's predicated on the idea that the First Amendment protects the right of oppressed people, oppressed classes, to express themselves. And you read the majority opinion from Justice Kennedy about this connection between the First Amendment and the right of the oppressed, and it's eloquent and moving until you recognize that the oppressed class he's talking about is the corporate class. And that he's worried about the right of DuPont and Exxon and Walmart to speak out and not be unfairly discriminated against. And that's why we got Citizens United. We got another decision later on that sort of deepened it, and a couple others. And what it stands for, this right of corporations to spend whatever they want, but what it has enabled is a Wild West era in campaign spending. And so the world has become the political world has become materially worse since that 2010 decision. In 2012, there's about $6.5 billion spent on federal elections, which was a huge record. And you get these records, right? It becomes numbing. So this year we're going to smash that for sure. Those numbers totally undercount how much is actually being spent for a variety of reasons. The advertising business says that they tallied $9.4 billion in spending on political matters in the 2012 election cycle, and they expect to get almost approach $12 billion this year. That itself would be an undercount. So the amounts involved are just extraordinary. And what are the impacts? Most of the things that follow from this are familiar to people, but actually how bad it is maybe not be completely obvious. One thing that's long been the case is that the need to fundraise for political candidates means they spend their time with rich people, and that affects what they think and what they say and what they do. President Obama may have spoken and written about it more eloquently than anybody prior to Citizens United in his book Audacity of Hope. He's saying, well, he's running for Senate, what was he doing? Increasingly, I found myself spending time with people of means, law firm partners, investment bankers, hedge fund managers, and venture capitalists. As a rule, they were smart, interesting people. They were knowledgeable about public policy, but they reflected almost uniformly the views of their class. And he says, and I started to think the way they thought because I was hanging out with them all the time. Just more precisely, if you sort of look in the 2012 election, the New York Times reported right at the end of the election that the President, Obama, had attended twice as many fundraisers in the course of the election as he had attended campaign rallies. And that Mitt Romney sort of disappeared for long periods, only doing an event a day because he was so busy fundraising. And if you wonder what happened to Hillary Clinton in the August period, part of it was a strategy to sort of see if Trump could just sort of shoot himself in the foot or head every day. Didn't work out perfectly, unfortunately. But a lot of it was that she was spending all her time fundraising. So where was she? Like if you had friends in Los Angeles or San Francisco, they'd tell you the traffic was messed up every day because Clinton was riding around going to fundraisers. It's kind of funny. But even all this, so that's sort of what happens to the candidates. But the money that we talk about is worse than it seems at first glance because the money doesn't just get spread out equally. It gets focused in the most competitive races. And what we now have is all this outside money, the super PAC money and this so-called dark money that Citizens United enabled and spurred along, coming in at astounding numbers. There's $1 billion in 2012, and it'll be way more this year. But it gets really focused in the races that are tight. So in the tight Senate races, most of the time, the outside spending groups spend more than the candidates themselves. So they get to decide what really is being debated and discussed. They spend almost all of their money on negative ads. Everybody hates negative ads, but they work. That's why people use them. The candidates are a little bit deterred from using negative ads because they can be held accountable. But these outside groups, American Future Fund, whatever, Americans, whatever Colbert's parody was, is indistinguishable from the real thing. Americans for a Better Tomorrow. The outside groups spend 85 to 90% of their money on attack ads, and that becomes what the races are about. So the state of the political dialogue is meaningfully degraded. And then, of course, we have a lot of that money coming in the form of secret spending and dark money, which means you can't even trace where the money's coming from. So the one thing you might be able to do to hold the groups accountable is identify who the funder is. But when all the funders are secret, you can't do it. So the vast majority, you hear these numbers, the Koch brothers were going to raise almost $1 billion. They scaled that down because they don't like Trump so much. But they're going to spend easily $500 million through their network. You won't see the Koch brothers anywhere that near money. They'll come in for a couple $1 million in disclosed spending. And all the money they're pouring in is going through groups that don't actually report. We do have some rules still in the books about campaign finance, but they're not enforced and they're honored in the breach. As the former chair of the Federal Election Commission will tell you, anyone's free to break the rules, she says, because there is no enforcement from the enforcement agency. Super PACs are not supposed to coordinate with candidates. No one thinks that doesn't happen. They used to say it was a wink and a nod, but maybe now it's a nod or something because the wink is gone. I mean, they're out and out coordinating. Money sloshes around between different organizations, so you can't follow and track what went from whom to where. And then thanks to another Supreme Court decision in 2014, the McCutcheon decision, you can put together these strings of political committees and make it possible for individuals to donate directly huge amounts of money to candidates, up to $3 million. You may remember there was a huge fundraiser that was controversial during the Democratic primary that George Clooney hosted for Hillary Clinton. And to sort of get a good seat at that fundraiser, you had to contribute $300,000. And it's worth asking, why could anybody contribute $300,000 if the maximum contribution in a primary is like $2,700? That's because the Supreme Court said, well, you can string all this money together, you compile all these committees, and you write one check, and it's all fine. So stuff is really honored in the breach. That's kind of like, I think, sort of the lay of the land of some of the key elements of this, but some of the consequences maybe aren't sufficiently recognized. I think there's two that I think are sort of dominant. And they're sort of obvious, but maybe less obvious than it first appears. The first one is that all this money that's coming in, it's provided by an incredibly small number of individuals and corporations. It makes sense to sort of think about them together as a corporate class, like a really, really small number. So I would say that Occupy Wall Street, which did a great service to the country, kind of got it wrong, right? All this discussion about the 1%, right? The other 99, 1%. That doesn't explain what's going on in campaign funding. If you talk about, we need to talk about the top 0.01% to get any insight into what's happening. So the top 0.01% take about 4% of national income. It's about 30,000 people, something like that. They provide 40% of all campaign contributions. Top 0.01%. Even that actually undersells the story. So if you look at super PACs as sort of the cutting edge or the worst stuff, you're really looking at about 100 people from election to election who dominate what's going on. Usually the top 100 donors are responsible for about 3/4 of the super PAC money. In 2012, there were 52 people or families who gave more than $1 million to super PACs. This year, we're already at 100. So I guess the benchmark for being taken seriously rises. Not surprisingly, these people are overwhelmingly male. People of color don't have this kind of wealth. So almost all of these giant contributions come from white people. The other thing that's really underappreciated is the extent to which all this money controls what's debated. So if we connect back to that long list of things that Americans agree on, they're mostly not even talked about, or they're not talked about as much as they should be given the consensus in the country. And they're not talked about because that interest doesn't line up with I'm like Rudy Giuliani here getting a cell phone call, sorry. That interest doesn't line up with the donor class interest. And the politicians have to be responsive to the donor class to be taken seriously. So at the end of the day, the donors decide effectively who runs. They have a huge influence over who wins. They have a giant influence over what's debated, what's even raised as serious political conversation. Then, of course, after the election, what's going to be talked about seriously in Congress. So what do we have to do about it? Well, the policy agenda is pretty straightforward, and Americans don't have any disagreement about that. Just like all those other numbers, Americans are completely consensus on the need for far-reaching reform. Depending on what poll you look at, it's between 80 to 10 and 90 to 10 who want reform. The New York Times had a remarkable poll that said the country is split not over the need for reform, but whether the system needs fundamental change or to be completely rebuilt. I'm not actually sure which is the more radical one of those two, but that's basically, everybody agrees on one of those two things. Nobody agrees that the current system is fine or even needs small changes. And the changes that we need are familiar. So the small bore thing is to have disclosure. Everything should be all the money, outside money, direct contributions, all of it has to be disclosed. You just have to end the sort of silliness of secret money dominating our elections. We need to have a system of public financing for our public elections. There's good systems in New York and elsewhere that show us how to do that. And we have to overturn Citizens United and other Supreme Court decisions that both entrench this ludicrous notion that corporations should have the same rights as people to affect our elections, but also make it possible to have all this outside spending. The good news is that Americans completely agree on that agenda. But we know from the first part of the conversation that agreeing on the agenda isn't enough. People have to get mobilized on it. And people actually, since Citizens United, have been. And we've had a change in what the conversation is on money and politics from kind of a boring good government thing to a fundamental democracy issue, a corporate power issue, and understanding the connection between the money and politics issue and corporate power and everything else that the whole agenda that Americans want to see realized. So just using the constitutional amendment as a marker, we went from 2 senators who supported an amendment in 2010 when the idea was thought to be either frivolous or too extreme, to 26 in 2012 when it started to gain traction. We had 54 US senators voting for a constitutional amendment, remarkably, in 2014. One of the presidential candidates now says that she would introduce an amendment within the first 100 days of taking office, and it's a core part of the agenda for the Democratic Party, remarkably. So we haven't broken through yet all the way to win. This used to be a bipartisan issue. Mitch McConnell has stopped that, but it will be again in the near future. The total key to winning is mobilizing, right? The polls are insufficient. Everything is about showing there's passion and that people care. This past spring, we had the first large demonstration around democracy issues in a generation, the first by money in politics maybe ever in Washington, D.C., with 5,000 people turning out to support the agenda that I just talked about, as well as a broader democracy agenda focusing on the crucial issue of voting rights as well. That was a good, small first step. We have to be at least an order of magnitude bigger, with people literally laying down in the streets to make a difference. That's what we have to do to win, and we have to win on this issue to win everything else that's being talked about at this conference. We're talking about breaking through power. This is really a central issue for breaking through power. Last thing to say is, okay, how do you get connected? If you don't yet know the website for a public citizen, you really should. It's citizen.org. Please sign up for our email list. We will send you a lot of fundraisers, but we'll also send you a ton of information about things you can do. And if you actually care to be really involved in organizing and want to get you hooked up with the on-the-ground organizing that's going on across the country in these red states and in the blue states to win this fundamental democracy reform. Thank you very much.
Our first speaker is going to be talking about the importance of whistleblowing. He is Professor Emeritus at American University, Washington College of Law. He has been a scholar in residence with the law faculty of the King's College of the University of London. He has also been a visiting professor at Monash University in Melbourne, Australia, and he has taught at the University of San Diego School of Law, as well as a visiting professor at Ritsumeikan University School of Law in Kyoto, Japan. Please welcome Robert Vaughn.
Thank you very much. As a teacher, I was always a little concerned when I was assigned that first class after lunch, but we can move from there. One Australian observer of whistleblowing concluded, "Whistleblowing is the legal regulation," and I quote, "most crucial to integrity, accountability, and organizational justice in all institutions," end quote. Even if you might be a little skeptical about that statement, which, by the way, I am not, we recognize that whistleblowing is a powerful technique for holding the powerful accountable. I will describe the importance of whistleblowing law by examining several different perspectives that are linked to different frameworks of accountability. These perspectives are a reservoir of arguments and proposals for change. Through them, we can consider the history and the expansion of whistleblowing laws in breaking through power. But I can't begin this discussion without mentioning those whistleblowers who have changed the perceptions of the public of whistleblowing and who have established the context and content of many whistleblower laws. But without an appreciation of these persons, whistleblowers become kind of insubstantial legal creations. An appreciation of their accomplishments and sacrifices make whistleblowing concrete rather than abstract, personal rather than statistical, and emotional as well as analytical. I will not forget them as I speak, and I ask that you do not. We're going to discuss these four perspectives: the employment perspective, the open government perspective, the transparency or market regulation perspective, and human rights. The New Deal labor reforms in the 1950s developed an anti-retaliation principle that prohibited retaliation against employees for disclosure of violations of labor laws or workplace protections. In the 1950s, a few courts, particularly those in California, used the anti-retaliation principle to restrict dismissals of at-will employees when those dismissals would be against public policy because those employees reported violations of law by their employers, violations of both regulatory and criminal law. This history helps to explain why whistleblowing laws are usually treated as a subset of employment laws. The character of modern society also explains this conception of whistleblower laws. The activities of contemporary society rely heavily upon the activities of government through government agencies and the activities of private organizations through corporations. Both private and public sector organizations can vary in size, but except for the smallest, they require employees to carry out their activities. These employees possess information not otherwise available regarding misconduct, incompetence, corruption, and dangers and risks connected with the organizations that employ them. Employees and employers, therefore, may properly see whistleblower laws as changing the relationship between them. If whistleblower laws restructure the workplace, this reduction in the power of employers invites widespread and lasting opposition to these laws. This perspective invites the consideration of the interests of employers who can argue that it is the public interest, not the interest of employees, that must be considered. Thus, it is the employee who must prove the entitlement to protection, and the employee does this in a setting where they normally face the resources of the employer alone. The other perspectives are information-based. The employment perspective is not. In the employment perspective, the emphasis is on the employment relationship, and that relationship incorporates interests in bureaucratic secrecy, secrecy that is asserted to be justified because of the need for rational decision-making and the preservation of management prerogative. This perspective contains other difficulties as well. It incorporates the procedural and administrative mechanisms of employment. These administrative and procedural mechanisms usually benefit employers. It requires the determination of who is an employee, and it requires the determination as to whether retaliation takes place through an employment-based action. Both of these requirements invite subterfuge and abuse. It is less likely than the other perspectives to draw on international law and on international organizations. International labor standards are ambiguous as to whether employees who make disclosures that do not involve violations of workplace laws are protected. And the International Labor Organization lacks the status and influence of international human rights and anti-corruption organizations. Because of its pervasiveness, the employment perspective is a powerful alternative to the others. The open government perspective. This perspective emphasizes the public right to know about government policies and practices. Freedom of information laws offer the justifications for disclosure of information held by the government. A principal justification for this disclosure is sustaining democratic accountability. Democratic accountability involves both political accountability and legal accountability, and open government laws support both types of accountability. As to political accountability, ignorance of the action of government officials makes criticism of the government less likely. Ignorance dulls outrage and reduces the likelihood that civil society groups will organize and use democratic procedures for change. As to legal accountability, the accountability of government officials, on the one hand, requires an understanding of the standards and practices that are to guide their conduct, and on the other hand, requires information about the conduct of those officials. The open government perspective introduces a dispute about the role of government. One view of the role of government is a limited view that in order to preserve the realm for private activity and choice. The other, more activist view of government says that the democratic state must address societal maladies that individuals are unable to resolve. The activist view sees the individual at risk not only from government, but from the concentration of private power from which the individual must be protected by the government. Both views identify corruption as a threat to the mission of government. The open government perspective affiliates whistleblower protection with international anti-corruption movements and that also advocate democratic accountability and disclosure. In contrast to the employment perspective, the open government one is information-based. Nothing in this perspective necessarily requires that protection apply only to employees. The market regulation or transparency perspective. This perspective evidences a concern with open markets. For example, with the flow of capital internationally, it requires an assessment of political risks and argues for knowledge of the frequency of corruption. The lack of transparency of markets or of government can be a surrogate for the likelihood of corruption. Corruption distorts markets. For example, corruptions in government contracts distort not only domestic markets, but can distort international markets as well. Whistleblower protections are information provisions that help to support efficient markets. Such whistleblower provisions thus become part of anti-corruption efforts in many countries, in international conventions, and in international economic organizations such as the World Bank and the regional development banks. Although concerned with the protection of markets, this perspective implicates misconduct by government officials as well, as the open government perspective can apply to non-government disclosures. The market regulation perspective can encompass information about government. These protections need not apply to employees because Hello? Oh, it's back on. Okay. Either that or my voice suddenly disappeared. I wasn't sure what. The protections need not be limited to employees because a number of individuals possess information relevant to the evaluation of markets. For example, the Inter-American Convention Against Corruption extends its protections for disclosures to, quote, public servants and private citizens. The breach of fiduciary duties by corporate officials often involve the suppression of information or the presentation of false information. This concealment and falsification of information distorts markets, particularly markets in corporate securities. While the open government perspective can be seen as an information-based approach to the accountability of government, the market regulation perspective can be seen as an information-based approach to the accountability of markets. In response to the Great Depression of 1929, the New Deal used information disclosure as a method of market regulation. Two recent examples emphasize this approach and the increasing importance of whistleblower protection. The Sarbanes-Oxley Act responded in the whistleblower provision to the failure of Enron and WorldCom, failures that were caused by accounting fraud. One of the best-known whistleblowers of the period, Sharon Watkins, who was named a Time Person of the Year along with Cynthia Cooper, who was another corporate fraud whistleblower, sought to inform corporate officials of these fraudulent practices. Unfortunately for her, all of the officials she approached were deeply involved in the fraud. The legislative history of the whistleblower provision of the Sarbanes-Oxley Act refers to this role of Sharon Watkins. The financial crisis of 2008 led to whistleblower protections in the Dodd-Frank Act. The provision contained important innovations and reflected the importance that was attached to whistleblower protection as a regulation of markets. Health and safety regulation, in the view of many, reflect an importance beyond the integrity of financial markets. The loss of human life and human suffering of these deaths and injury demand effective regulation of health and safety. The inadequacy of industry standards in industry after industry has generated a wealth of statutes. The information disparity between regulators and regulated industries is accepted as a principal reason for regulatory failure. This information deficit disables regulation. Beginning at least with the Mine Health and Safety Act of 1977, whistleblower protection has been used as a tool for ensuring adequate information regarding workplace risks or public safety through protected disclosures to regulators. Many environmental and health and safety statutes contain whistleblower protections. Important whistleblower provisions are included in the Consumer Product Safety Improvement Act of 2008 and the Food Safety Modernization Act of 2011. Since 2000, Congress has enacted or significantly amended more private sector whistleblower provisions than in any comparable period. Federal private sector laws now cover tens of millions of private sector employees. The human rights perspective. Freedom of expression has played an important role in the development of whistleblower protection in the United States. In 1968, in Pickering versus Board of Education, the United States Supreme Court applied the First Amendment to protect public employees who made disclosures to the public. The whistleblower provision of the Civil Service Reform Act that covers millions of federal employees sought to vindicate these constitutional rights, but it substituted statutory standards for the vague balancing test under the First Amendment. In this sense, U.S. whistleblower law rests on the human right of freedom of expression. This perspective gives whistleblower protection a strong connection to international human rights law. For example, both Article 19 of the Universal Declaration of Human Rights and Article 13 of the American Convention on Human Rights protect freedom of expression. The right has been broadly interpreted by the Inter-American Court of Human Rights. In Reyes versus Chile, the court held that this right of freedom of expression gives the individual the right to receive information about the government and imposes upon the government an obligation to provide information to citizens. International human rights contains a large body of ideals, principles, and arguments. Powerful international organizations support the development of human rights. Under many human rights conventions, signatories are bound by the decisions of judicial bodies who are charged with interpreting the convention. For example, decisions of the European Court on Human Rights have helped to develop human rights in Britain. Whistleblower rights in Britain. A human rights approach relying on freedom of information is more likely to encompass opinion. Therefore, This perspective supports a broader scope of protections and under more lenient standards than reasonable belief. The freedom of expression applies to public disclosures, and this perspective, more than the others, is likely to protect public disclosures. The principle of the indivisibility of human rights would protect disclosures addressing other fundamental issues of human rights. The human rights perspective is not instrumentalist, as are the other perspective. With them, protection is granted to serve some other value or interest. A human rights analysis focuses less on human rights as a way to implement other values or to accomplish worthwhile goals, but asserts that these rights represent basic human values worthy of protection. The task of breaking through power is not an easy one. Whistleblower law is often seen as a way of doing so. To understand the weaknesses of whistleblower law, but more importantly, to appreciate their possibilities requires an understanding of these perspectives. Because of these perspectives matter, examination of them helps us to see the weaknesses of whistleblower law and to appreciate possibilities for change. Each of these perspectives enables and limits whistleblower protection, and examination encourages us to seek significant change. By the way, for the students here, I'd like to give a little warning. And that warning is be very careful what you do when you're 26 years old. When I was 26 years old, I turned down a couple of jobs and took a job with Ralph Nader in Washington. And one of the tasks that he charged me with was looking at the federal civil service. And one aspect of it that I came to particularly focus on was the need for whistleblower protection for federal employees. So now, some 40 years later, I'm still working on the same topic that I was assigned then. So just an alert, please be extremely careful what you start with when you're 26 years old. Thank you.
Our next speaker is going to address public sentiment and social change. He is professor of politics and chair of urban and environmental policy chair of the Urban Environmental Policy Department at Occidental College. He writes widely on American politics and public policy for The Nation, American Progress, Dissent, and the Huffington Post, as well as numerous op-ed pages in the newspapers. He is author of the 100 Greatest Americans of the 20th Century, a Social Justice Hall of Fame, and he has also led the successful minimum wage campaign in Pasadena, California. Peter Dreyer.
Many of the radical ideas from the past, ideas that were once considered utopian, radical, socialist, crazy, impractical, are now things that we take for granted. And those things include Social Security, the minimum wage, women's right to vote, the right of workers to unionize, a progressive income tax, consumer and environmental protection laws, national parks, government-subsidized health care, same-sex marriage, a black president, and a woman president. All of those were once considered radical ideas. So the radical ideas of one generation are often the common sense of the next generation. How did that happen? In order to understand that, we have to understand where we've been, where we are, and where we're going. And for those of you that are somewhat demoralized or depressed by the current political situation, have no fear. This too will pass. Movements make change. Movements make it possible for us to dream dreams. Movements make it possible for people to think that radical ideas today will be taken for granted by our children and our grandchildren. Dr. King said the arc of the moral universe is long, but it bends towards justice, but he forgot to say one thing. Who's going to bend it? Who's going to make it possible for that arc of the moral universe to bend? And those are the people I want to talk to you about today. Very quickly, a big overview of the movements of the 20th century that have made our lives a lot better, whose shoulders we stand on, but whom we often forget. Victor Berger was the first socialist congressperson from Milwaukee. In 1911, he introduced this crazy idea in Congress called old age insurance. He got one vote for that bill. That was his own vote. But 25 years later, during the New Deal, during the Franklin Roosevelt administration, we adopted Social Security. The radical ideas of Victor Berger became the common sense of our ideas today. These three women were part of the leadership of the Settlement House movement that created the fight for against slums and against sweatshops in our big cities. They were mostly upper middle class women that moved into the immigrant slums of the late 1800s, the early 1900s, and they fought for the rights of immigrants. They helped to organize unions. They helped to organize what today we would call consumer groups. And they created things like the minimum wage for women and laws protecting people from slum housing. The Triangle Factory Fire in 1911 mobilized a big movement. 145 immigrant young teenage girls were killed in this fire in New York, but there was a protest movement after it. Francis Perkins, Al Smith, later the governor of New York, Robert Wagner, were three activists in that movement. One of the people that was one of their supporters was a woman named Anne Morgan. She was the daughter of the richest person in the world, J.P. Morgan, but she decided she wanted to be on the side of the working class women, so she showed up with her rich friends at the picket lines. Rose Schneiderman was a union organizer at the time. She couldn't believe that this upper class woman in fur was out there in the middle of the winter picketing with the working class women. She called them the Mink Brigade, right? But they were people who were in solidarity. That's how Eleanor Roosevelt first became politicized, by the battle over the Triangle Fire. There were people fighting robber barons, these muckraking reporters and writers, Lincoln Steffens, there should be an S on the end of his name, Upton Sinclair, Ida Tarbell, who took on Standard Oil. There was a women's rights movement. This is 2016, exactly 100 years ago. Next month, two important things happened. One is that Margaret Sanger opened the first birth control clinic in America in Brooklyn, for which she was arrested because it was against the law to do that. And Jeanette Rankin was the first woman elected to Congress in 1916. These are things that we now take for granted, birth control and women in Congress, but they were really revolutionary 100 years ago. Workers' rights, workers sat in the Woolworths in New York, in the Detroit and Flint factories to get the right to unionize. The sit-in movement, which took its idea from the working class workers movement, brought us civil rights, the right to vote, the right to accommodations. Right? The environmental justice movement challenged and changed the law and introduced the Clean Air Act, the Clean Water Act, the Environmental Protection Act in 1970. These are all radical ideas at the time. The consumer protection movement, led by Mr. Nader, but also by a woman named Frances Kelsey, without whom many of my generation would be thalidomide babies, because she was a doctor at the Federal Drug Administration, Food and Drug Administration, and she stopped the drug companies from allowing the Food and Drug Administration from allowing the drug companies to sell this very dangerous drug, thalidomide, which saved millions of lives. Tony Mazzocchi was one of the leaders of a movement for workplace safety that helped to create the Occupational Safety and Health Administration in 1970.